Thanks so much, Mike. Welcome to today's program titled 2020 U.S. Election, How Will Immigration Change Under the Biden-Harris Administration? At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to Diane Delvecchio-Hilburn. Diane, please go ahead.
Today we have a terrific panel. I am joined by three of my favorite partners, Leon Rodriguez, Angelo Paparelli, and Gabe Moses. So what I'd like to do, next slide please, Kelly, is give you just a little flavor for what's on our menu for today. We're going to talk about where we've come from and where we are today, how this future administration might enhance the talent pipeline to the states, what's going to happen with DACA, TPS, interim final regs. We have a whole crazy quilt of things to talk about today. But first, because past is prologue, we want to take a whirlwind tour through history. It's going to be fast, so this is not the time for you to get a cup of coffee because you might miss a few years. We want to talk about what other presidents have done before President-elect Biden and the effect of some of those decisions and really how they have led us to where we are today. Next slide, please. So let's start with Ronald Reagan. In 1986, there was a really massive overhaul of immigration called IRCA. It brought us the I-9 form, which had never existed before. It brought us fines and penalties for knowingly hiring people who didn't have authorization to work in the US. And it also, very big deal, created a legalization program whereby people who had been undocumented for a certain amount of time had a path to a green card. Next slide, please. Fast forward to George Herbert Walker Bush, Daddy Bush, a very big piece of legislation known as IMACT 90. It brought us a lot of changes. It created the EB1 through EB5 categories that we work with today. It created the EB5 investor program. It created a path to self-sponsorship for the green card through the alien of extraordinary ability, outstanding researcher, outstanding professor, national interest waiver, some of those new flavors that came about. It created the O and the P categories, and it also addressed the H-1B program and created a cap of 65,000 spaces for H-1B visas that could be given out each year. In addition, it addressed hardships around the world, either political or climate or other, by creating the TPS, or the Temporary Protected Status program. It also, interestingly, remember this is around the time of the Tiananmen Square protests, created an act, first an executive order, later memorialized as an act, to create a very direct, very swift path to green card for certain Chinese students. So that was a big deal. Next slide, please. Fast forward to Bill Clinton. So in Bill Clinton's administration, there was an act, we call it IRA because the long form of the expression is way too long, but that was what introduced the bars to reentry, what we call the 3 and 10-year bars. So if people have been in unlawful presence, if they've exceeded the time on their I-94 card for a certain amount of time and depart the US and try to get back in, that's what the block is. And so that was quite a big deal. I think it was intended to get people to decide to leave the US rather than face the bars. I think what it had was some unintended consequences because it, in fact, increased the number of folks who were undocumented. IRA also expanded greatly the definition of aggravated felony and led to a different approach to deportation, which we call expedited removal. It also, remember, the economy was burgeoning at this time as we were approaching the turn of the century. So it recognized that by increasing the numbers for H-1Bs up to 115,000, it was temporary, and that particular section was sunset. It also created no benching rules to try to create more fairness for H-1B employees and ensure that they had work in the pipeline. This is also what created the ACWIA training fees and the fraud fee that go to finance investigative efforts of CIS. And thankfully, it created the exempt employers, the colleges and universities, the hospitals and research institutions, and the not-for-profits. Finally, what ACWIA did was create the doctrine or the concept of H-1B portability, so people didn't have to wait for their approval to come through before they could actually start working for their new employer. So I promised you that would be fast. We have one more president to go through, and that is George W. Bush. Next slide, please. And so this was something that never happened, unfortunately, but on the day before 9/11, there was a meeting scheduled between George W. Bush and Vicente Fox, who was then the president of Mexico, to talk about ameliorating some of the situations and to try to create a better structure for Mexicans in the US. Unfortunately, that meeting never happened, and because of the events of the following of 9/11, unfortunately, that got put way, way down on the priority list. What we also want to flag, because this is really where it started, is in 2007, 2008, as the economy started to get wobbly, it started regionally, and then as we know, in October of 2008, it really blossomed into a global recession. That's when we started seeing a trend of requests for evidence, or RFEs as we call them, on the grounds of specialized knowledge, and also for L1Bs on the grounds of, on the grounds of specialized knowledge for L1Bs, and on the grounds of specialized knowledge for the specialty occupation for the H1Bs. So with that, I'm going to turn it over to Leon Rodriguez, and he's going to talk about the Obama years.
Good afternoon, everybody. My name is Leon Rodriguez. I'm a partner in Seyfarth's Washington, D.C. office. Actually, from 2014 to 2017, I served as director of USCIS. I've been at Seyfarth since, and among my roles here is I am the chair of Seyfarth's Government Relations Practice Group. So you have the Obama years, and in some respect, I think it's fair to say that the last 12 years have been essentially a debate between the Obama vision of immigration and the Trump vision of immigration, which we're going to talk about in just a few moments. But you did have, coming on the heels of the Bush attempt at comprehensive immigration reform, another effort at immigration reform occurring under the Obama administration. And this, in some respects, typified the legislative process in the Obama years, in the sense that the president would sort of give a general command, express a general aspiration, and then it would actually become the work of the Congress itself to really craft what would be the ultimate bill. And so you did have, in that time, a gang of eight. I just learned today in preparation for this that there are gangs of eight for all kinds of things. There's a gang of eight for intelligence, a gang of eight for immigration. So anything that anybody cares about gets a gang of eight. So immigration got a gang of eight, starting very early on the Obama administration, for Democrats, for Republicans, who set about what ended up being a very challenging task of reaching a compromise for a comprehensive immigration bill. And I think it's worth pointing out, especially as we enter a new Biden administration, that it still remains a basic article of faith for Democrats that piecemeal immigration reform is unacceptable, that only comprehensive immigration reform is acceptable. And so you might see little efforts to peel off one issue here, one issue there, and you'll see that there will be, at least in some quarters of the Democratic Party, resistance to that. Ultimately, there was a bill overwhelmingly passed in the Senate. It had a lot in it. It had a path to citizenship for individuals who had been in the U.S. in an undocumented status for an extended period of time. You had a number of reforms to expand access to employment-based visas. You also had significant border security provisions in that bill, as well as the elimination of the what's called the diversity visa program. So it really covered many different aspects of what had been the immigration debate up to that point. It also had, importantly, it had a point system, which is something that also has come up in the Trump administration, to establish essentially a scoring system to determine who would qualify for a green card and therefore permanent residence in the United States. It passed overwhelmingly in the Senate. It ultimately was killed by then Speaker Boehner, in part because of what was clear resistance by certain elements of the Republican Party at that time. Because of that congressional stalemate, you then had the introduction of what eventually became the Obama executive orders on immigration. So the first iteration of that was in 2012, when you had the Deferred Action for Childhood Arrivals program. This provided both relief from deportation and employment authorization for people who had come to the U.S. Initially as children, were in the United States unlawfully at the time of their application for deferred action, had never been convicted of a serious crime, and had either studied in the past or were at the time of their application studying. And this became sort of the first significant effort to provide some real relief for deportation for a segment of the undocumented population. In this case, ultimately close to 800,000 people at one time or other held DACA status. Probably close to 700,000 hold it even as we speak today. The other thing to just quickly point out is that there were a number of other executive actions that were undertaken by the Obama administration in addition to DACA. In 2014, just after I became director, we received a directive from President Obama to build a set of executive actions which would further expand the DACA program to include individuals who are parents of U.S. citizens, legal permanent residents, but were in the U.S. unlawfully, to take a number of actions with respect to employment-based visas, to change the enforcement structure for immigration and customs enforcement, and also to expand avenues of relief from those 3- and 10-year bars that Diane had mentioned early on in her presentation today. Ultimately, we ended up spending a whole lot of time in court, and probably what was the crown jewel of those executive actions, which was the deferred action for parents, was ultimately enjoined and stayed enjoined all the way up to its consideration by the Supreme Court. That then created the tableau in which the first for the Trump campaign and ultimately the Trump administration. And so while the main principles of the Obama immigration program were one, that the continued sort of existence in the shadows of a large part of the undocumented population was untenable, that the U.S. should continue to have a sort of welcoming policy toward immigrants, that all of those were the sort of centerpieces of the Obama philosophy. That leads us in the next slide to really the Trump view, which was really based on the following intellectual premises, which was first that the immigration system, as it had been run both by President Obama and President Bush, one was harmful to U.S. workers. It resulted in the displacement of U.S. workers, that it invited both national security and public safety threats into the U.S. And so therefore the sort of opening represented by the Obama approach to administration needed to be reversed fairly decisive. And what you have here then is a pretty good outline in this slide of what the essential components of that approach were in the Trump administration. All told, there's actually a project run by a friend of mine that tracks this. There were 900 executive actions. There have been, rather, 900 executive actions to date on immigration. They all began with a series of proclamations and executive orders issued by President Trump, and some of them in the very first days of his administration. One of the things that I said I've noted a bunch of times that really distinguishes the Trump administration from any prior administration was the fact that he tackled immigration head on, whereas a lot of other administrations, both President Bush and President Obama, noting how politically freighted this topic can be, waited until late in their administrations to take action on immigration. In fact, President Trump waited approximately 4 days before issuing those first travel bans that created all kinds of drama at the airports throughout the country very early on in administration. In addition to a number of more enforcement and border-focused executive orders, you then had the Buy American, Hire American executive order, which was issued in April 2017. And that directed a series of reviews and ultimate policy changes, both within the Department of Homeland Security and the Department of Labor, the intent of which, again, the intellectual underpinning of which was this notion that the immigration system had operated insufficiently to protect U.S. workers, that it had been beset by fraud, and that therefore action needed to be taken to reverse those trends. That resulted in a number mostly of policy issuances for probably the first 3.5 years of the Trump administration. And you'll hear a little more about this later, but then as COVID deepened as a reality for this country, the administration then used that reality to leverage a series, first of all, of travel-related executive orders, and then just in the last 3 months or so, a number of regulations addressing employment-based immigration, changing the prevailing wage structure, narrowing the standards to qualify in the H-1B classification, changing the structure of the H-1B visa lottery, changing the manner in which duration of status, the duration of status is determined for student visa holders. We have had DACA has obviously gone back and forth in the court. We've had a number of issues at the border accepting parents and children. So this all has been, these have been sort of many of the hallmarks of the Trump administration. Next slide, please.
Hello, my name is Angelo Paparelli, and I'm here on the West Coast and observing things from a distance, but nonetheless heavily immersed in business-related immigration law for many years. Well, picking up from what Leon said, one of the more consequential developments in the Trump administration was an early determination that the agency would seek to defer or exercise discretion when it adjudicated requests for extension or renewal of previously approved grants of immigration benefits, work permissions. And what that had the effect of was to require full-blown briefing and the collection of a body of evidence to demonstrate on every ground of eligibility why the applicant for renewal, who, by the way, is in the job right now, should continue to receive those work permission benefits. And unfortunately, what we have found was that in response to the end of the deference memo, what happened was that the number of requests for additional evidence, as well as the number of notices of intent to deny and notices of intent to revoke, mushroomed dramatically. And as you can see from the slide image, the increase in RFEs, requests for evidence, ramped up by 40% over the last few years, and it's pretty much stayed there. We have also seen somewhat surreptitious changes arise in the way that forms have changed. There is a regulation under the USCIS regulations that says basically the instructions to forms are incorporated by reference into the regulation. And that has a way of short-circuiting the normal procedure under the Administrative Procedure Act, whereby the public and immigration stakeholders are given an opportunity to be aware in advance of what is coming down the pipeline and to offer comment and observation in the hope that the agency will slow down and maybe reconsider or take a different approach in the way it makes changes. But just as one illustration, we have seen a pattern that's been widely reported in the Washington Post in particular of refusing to accept government filings if not all of the boxes where data fields are requesting information are filled in, even though the particular question does not apply. An example being location of deceased relatives. I don't know that the agency really wanted to know the cemetery and gravestone site for every deceased relative, but what we are seeing is rejections that are hard to explain, but they have tremendously adverse consequences, because if a filing is submitted, particularly one seeking to continue pre-existing immigration benefits, and unbeknownst to the employer, the individual non-citizen, or the immigration firm, that the matter has been rejected without processing, the person goes out of status, begins in many instances to start tracking periods of unlawful presence, and if they tabulate, as Diane was mentioning, up to 6 months of unlawful presence, that can lead to a 3-year bar on reentry, as well as visa avoidance, requiring the individual to go back to their home country whenever they need to get a new visa and not apply anywhere else. And then if the period of time is more than 1 year, then there is a 10-year bar on reentry. There's also a consequence that a person may no longer be eligible to apply for adjustment of status because they failed to maintain status unless some narrowly interpreted forgiveness clauses that excuse such lapses are recognized. And there's also the consequence that people become removable and face an order of deportation in front of an immigration judge. That particular process is backlogged years because of the border apprehensions. And so a person would be in a kind of legal limbo for a prolonged period, unable to work, for a prolonged period not knowing what would happen to them if they departed the U.S. So these have been very, very consequential. And we can go to the next slide, please. So that's our summation of how we got here, but where are we now? We continue to have a population that's estimated to be between 11 million and 12 million undocumented individuals with no clear way to become lawful. There is no meaning to the phrase sometimes heard, why don't they just play by the rules? Why don't they just get in line? Oftentimes, even those in lawful status can find that there is no line, or the line may last for years and years, perhaps beyond the longevity of individual beneficiaries. We have seen the ups and downs, as Leon mentioned, of the Deferred Action for Childhood Arrivals program. Fortunately, the Supreme Court definitively determined that the Trump administration did not revoke DACA with adequate sensitivity to the administrative process. And although the response of USCIS was to decline to accept new DACA applications or renewal applications, just last week, a federal judge has ordered the agency to resume accepting those applications. We have also seen the vicissitudes of the temporary protection status. That is not administrative, that is rather a statute, but the statute gives the president the authority to determine whether there is a calamity or catastrophe in the person's country of origin such that they should no longer be required immediately to depart, and they would have protected status with the right to work. What we see from all quarters, despite COVID-19, we are clamoring for enough workers in a variety of industries and sectors of the economy, agriculture in particular, even the service industries, which have been deemed in many respects by various governors as essential industries, essential services. And that's not to mention the IT sector, which is experiencing a low level of unemployment. And that's ironic, unfortunately, because one of the travel bans that Leon mentioned was a labor market COVID-related travel ban that would have expired at the end of this month were it not for the fact that it was enjoined. And so much of the practice of immigration lawyers has been to try and get national interest exceptions and waivers to these regional and labor market visa and entry bans over the last several months. We continue to worry as well about the long-term impact of these anti-immigration policy changes, and whether as parents and their offspring in foreign countries determine the future of the children's education, they may wonder, or their careers, they may wonder whether America is the same attractive, welcoming nation that it once was. And that will be a long-term concern as to whether this creates a talent drain of decades of consequence rather than just the lifespan of a single presidential term. And then we've also seen discouragements that apply to F1 and J1 students and scholars. ICE, Immigration and Customs Enforcement, was sued by MIT and Harvard, and that suit was successful to prevent a policy change that would have shut the door on mixed or hybrid education in classroom and online education. But we've also seen, as I think Gabe will talk about, a change in the longevity or duration of the status of students and scholars and exchange visitors. And so we can go to the next slide now.
Thanks, Angelo. Thank you so much. And so there's a lot going on right now. I mean, present tense. There's just so much that we've had to wrap our heads around. You know, everyone on the phone, your employees are dealing with holiday travel right now. We're dealing with all this rulemaking. I just want to take a few minutes and kind of talk about where we are right now and what's at stake and what may go away and what may not. Then I'm going to turn it back to Angelo and Leon and really give us a better idea of what's going on with the Biden administration. But let's talk about what's happening right now, right? So we have some executive orders that relate to travel. We get this question every day, literally every day. What are we going to do about travel? I want to travel for the holidays. So we've got that regional COVID ban. If those of you on the phone recall, that's if you set foot, even if you transit through, right? You don't intend to, you just stopping through the airport, Schengen country, UK, Ireland, China, Brazil, and Iran. You are subject to that ban. And what does that mean? It means that you cannot travel from those countries to the United States without first going to another country that is not subject to the ban for 14 days, or you need to apply for national interest exception. And you know, Angelo alluded to this. The last few months, we have been working with clients and employees who are looking to travel on national interest exceptions. You know, the success rate is actually quite high, but the volume is increasing, and administratively, it's becoming harder and harder and harder to do them. So now that's going to continue. It'll be terminated by either President Trump. We actually recently heard that there was a rumor that it actually may be terminated sooner rather than later. We don't know precisely what the next administration is going to do, but we are hopeful that this will not continue after Inauguration Day. So that is something we're keeping an eye on. The other executive order that came through, the labor market entry ban, that's with the H, L, and J visas. That's to be able to apply for visa stamps at the consulate. That is set to expire at the end of the month, as Angelo said. But here's the deal with that one. I'm not sure the executive order is the bigger driver here, right? So that even if that expired, and there's been litigation on this, and litigation has been successful. But the bigger driver right now, actually, on that piece, on the ability to apply for visas, is COVID and the fact that most consulates and embassies have not resumed their routine services. So it's extremely hard to get an appointment. And getting an emergency appointment is basically, if you can get an emergency appointment, you've maybe effectively, you know, met the standards for a national interest exception anyway. So these are things that your employees I'm sure are listening to, are paying attention to as they plan their travel. We're answering these questions literally daily. We do expect, or we are hopeful, that's a better way to put it. We are hopeful that as, you know, especially as we round the turn, more with COVID than any other policy, that we are going to see some easier times ahead with renewing visa stamps and travel. The rulemaking is really interesting, and there have been so many recent developments. I'm sure many people on the phone are well aware of the recent Department of Labor wage rule that increased all of the prevailing wages. It increased the prevailing wages by, 40, 50, 60% in some cases. And that has affected H-1Bs and green cards. Department of Labor, the U.S. Chamber of Commerce filed suit against the Department of Labor, and I'll talk about in a second, Department of Homeland Security for an H-1B rule. And the courts didn't even need to get to the the merits of the case. So the Department of Labor wage rule, with the wage rule, the courts basically said that they were not able to demonstrate good cause for filing this as an interim final rule, meaning it takes effect immediately. And so in the Chamber versus Department of Homeland Security, this was in Northern District of California, Chamber won. And so now, if you go onto the Department of Labor website, all of the old wages are back officially. We are very excited about that. Our clients are happy. We are able to file labor condition applications as of this Wednesday. That will be up and running. And then Department of Labor will resume prevailing wage determinations for green card cases on the 15th, so 8 days from now. So that's going to be very helpful. The H-1B rule, and that rule by Department of Homeland Security, that one basically took this kind of the concept of an H-1B, job requires a very specific degree, and the applicant must have a matching degree. That took it to a much higher standard. It's basically almost an exact match, a 1-for-1 match, and that would have been, that would have been very challenging to do with a lot of different professions, because as we know, most professions you can have several degrees that fit. In any case, that rule was also published initially as an interim final rule by the government, by the Department of Homeland Security, and that also in court has gone away. So that was actually set to take effect today. That today was the implementation or the effective date, and that is not happening. So we don't know if any of these are going to be revived in the next, looking at doing the math here, 43 days or so. They may. We are watching intently. The one that's still there on the H-1B side, when we're talking about rulemaking, is the cap registration rule, right? H-1B cap. H-1B cap is a lottery. First come, first served, but they all come on the first day. They are picked kind of at random. And what the Department of Homeland Security has decided they wanted to do now is kind of scrap that framework. Leon mentioned before, buy American, hire American. We're talking about best and brightest, highest, in this case, the government has interpreted this as highest paid. So what does that mean? It means that H-1B cap numbers, according to the rule, will be allocated based on highest wage level. It goes to the highest paid workers. So that one right now is that is subject to notice and comments. The Department of Homeland Security has gone through normal rulemaking procedures. So we are, we've seen some member organizations and businesses file some very strong comments against the rule. Yet to be determined where that stands. That would obviously be a very big deal. If we can go to the next slide, and just to wrap it up with a couple little things, what we're doing now. So some really good news and some not so good news on the F1 and J1 front. So on the F1's front, if people have been following this WASH Tech case, there is a victory for OPT and STEM OPT. So F1 students, so basically WASH Tech was an alliance that filed a lawsuit to challenge Department of Homeland Security on trying to just get rid of OPT and STEM OPT. I mean, just literally dismantle the program. That's held up, right? So we were getting a lot of questions. What's the future of OPT and STEM OPT? And right now you can say the future is good, right? So that case is a final ruling that actually went into detail about why the court decided to move forward with allowing the program to stand, but we know that it is, and we're waiting for that final opinion. Mixed news.
Gabe, if I could just
yes.
add a point there.
Sure.
What was scary about that case was that it challenged the underlying authority of USCIS to give employment authorization documents to anyone, claiming that unless it was expressly authorized by statute, the administrative agency did not have the independent authority to grant work permission, which would have shaken us to the rafters because there are more than 30 different categories of so-called EADs, or employment authorization documents. So we are looking forward to seeing what the rationale of this decision is once the judge actually releases it.
That's a good point, Angelo. And the other piece here, this is a little bit more under the radar. We don't, you know, we're waiting for a little bit more information here. There is a rule out there, rulemaking, to get rid of the duration of status for F1, J, and I visa holders, and established fixed time periods. So we all know that F1 students, when they come in, they're admitted for duration of status, meaning how long it takes to actually complete their program and their OPT. The government wants to get rid of that and actually put time periods there. That's under notice and comment right now. A couple of really interesting things about this one. So first of all, they received 32,000 comments, which is a lot. And so they're going through those right now. But those students would get 4 years initially. Some will get 2 if they're from like a country that is state sponsor of terrorism, and you know, high overstay rate countries. But it would require students to file applications to constantly extend status, like we do with lots of different visa categories. And that's expensive, right? That's expensive and burdensome, and a high chance of potentially, you know, errors and individuals overstaying their I-94s. Now we have to be concerned about that. The grace period also would shrink from 60 to 30 days, which also is not a good thing. I'll tell you one interesting thing about this is that there is a plus here, that on the plus side, cap gap. Those of you guys that know, you get an extension of your OPT until October 1st for your H-1B to start. That would actually be extended until the following April 1st, because the government has finally conceded, yeah, we don't actually get them adjudicated before October 1st. So we're going to give you another 6 months to do that. In any case. All of this has led to anxiety and fatigue amongst our, you know, clients, employers, foreign nationals, us as attorneys. So we'd like to see things calm down a little bit. Maybe they will under the next administration. I'll turn it back to you guys so we can go to the next slide.
Thanks so much, Gabe. I just wanted to say, now that we've looked at the history and we've looked at the current state, Angelo is going to give us his thoughts on what we might be able to expect in the future state.
Angelo, you're on mute.
Apologize for that, but let's begin even before the appointment of personnel and recognize that the platform of the Biden-Harris administration already has communicated that it will immediately take a variety of executive actions to undo within the power of the president the previous executive orders that have been admitted or submitted and become effective. And Leon, am I jumping ahead of you? Did you want to jump on this one?
So please go ahead.
Okay. Well, the first major announcement is the appointment of the first Latino American Secretary of the Department of Homeland Security, one Alejandro Mayorkas, who is a former assistant U.S. attorney and is also predecessor to Leon Rodriguez, our panelist today, as director of USCIS under the Obama administration. Mr. Mayorkas had demonstrated an enlightenment to the value of immigration, both as family unity and economic prosperity, the prongs that have been traditionally the underpinning of our immigration system, and so that bodes quite well. In addition, the Biden-Harris transition team has appointed individuals who are well-known experts in the field of immigration law. A previous Chief Legal Officer of USCIS, Ms. Jadu, who also worked in Congress on immigration matters, has been appointed to head up the transition team. And frankly, what has been happening behind the scenes is the submission of a number of written recommendations that would not only undo, but restore benefits and expand upon benefits, expand upon the authority to grant benefits than had been customary over the last 4 years. So we'll talk a little bit more in a bit about what some of those proposals are, but what we are envisioning is a massive flurry of executive orders early on in the Biden administration. I think it was generally recognized that the focus of the Obama administration on health care, which was indeed important, and a deferral of statutory action on immigration led to a constraint that ultimately never allowed comprehensive immigration reform to come forward. And so I think they've learned that lesson, and we should see a flurry, perhaps a torrential rainstorm of new changes that we would welcome. So we'll be dancing in the rain, I would envision, pretty soon for those of us who believe that America should still be a welcoming nation of immigrants. We did see a major development last week in the passage in the Senate of S-386. This is a bill that has a companion in the House. The companion in the House will no longer be the moving vehicle for this legislation, and the Senate version will likely be the one that either is going to be accepted, modified, or rejected in the House, and then with a conference committee of the two chambers coming together to try to work it out. But one of the most fundamental things it does is it eliminates the per country place of birth restriction on immigration benefits in terms of getting a green card. If you had been born in India or in China or in a few other countries, that 7% annual cap of the worldwide total allotment would have caused you to have to wait for years and in some cases decades before immigration benefits would be available to you. Now, there will be a transition period, but you should know that this bill does many more things. It will enhance and ramp up the authority of the Department of Labor to engage in H-1B investigations and enforcement. It will eliminate what the Department of State has recently proposed to do anyway, which is the so-called B-1 business visitor in lieu of H-1B and H-3 visas for specialty occupation workers and trainees. And it is not clear that the House welcomes the changes that were brought about in S-386 from the earlier House version. So it is unclear whether that will be enacted in a lame duck session, I should say passed by both chambers and then brought to the President Trump for signature, whether he will in fact sign it. It's not, none of those things are entirely clear. And then another, to us immigration lawyers, bombshell was a discrimination claim brought last week by the Justice Department against Facebook, claiming an unlawful practice of preferring to hire foreign workers rather than U.S. workers in the PERM labor certification sponsorship program. And for those of us who've been around for years, this is not the first time that the Justice Department has come against immigration lawyers, employers, and the labor certification program. It dates back to efforts as early as in the late 1980s when this happened. But the the unresolved question, at least in the mind of the Department of Justice, is whether by following the Department of Labor's perm recruitment rules, one engaged in good faith recruitment or did not. And these rules, by definition, involve a test of the labor market to see if American workers would be available were a job offered to them. The Department of Labor has never required that the labor certification process leads to the hiring of workers, U.S. workers. All that it has held is that if you do not pass the labor market recruitment test because U.S. workers have applied and appear to be qualified, you do not get a labor certification for a 6-month period in which you would be open to trying again. So by definition, the way Congress set this up, there is normally an incumbent individual who has the job, a non-citizen who is being sponsored. Employers are required to go through a ceremonial process of a labor market test, but it does not mean that U.S. workers will necessarily be hired, and that seems to be what is overlooked in the Justice Department's case, that these were statutorily prescribed procedures to be pursued. We'll wait and see how that comes out. Next slide, please.
Okay, so the question, I think, as we hear a lot of the various issues we've talked about is when are these changes going to come? What is going to be the price of those changes, and what headwinds will affect what the shape of those changes are? And so a lot of this really turns on other priorities that for the administration may take precedence over immigration. And when we talk about immigration on a webinar like this one, we're really talking about immigration as it affects employers, and it affects access to a talent pool. And so one of the things that the Department of Homeland Security as a whole, or rather two things, two really critical things that the Department of Homeland Security as a whole is going to have to tackle really from day one, is first going to be the coronavirus pandemic, which is in fact a Homeland Security issue as much as it is a public health issue, and also the continuing pressures at the southern border of the United States. That's going to displace a lot of bandwidth and also a lot of political energy from some of these core immigration issues that you've been hearing about during the course of this session. Does that mean that the changes we've talked about that affect employers aren't going to happen? Doesn't mean that, but it does mean that the timing of when those changes are going to occur and what the shape of those changes could be affected. And there are a number of stakeholders that the administration is going to need to consider. You know, you'll often hear in the sort of pro-immigration world about the Business Bibles and Badges Coalition. And that talks about three of the important stakeholders: businesses, faith communities, and law enforcement communities. So those are stakeholders, but there's also coalitions of U.S. workers who worry about displacement immigration, and they've made their voices heard both in litigation and candidly made their voices heard through the ballot box in their election and their continued voting for President Trump in this past election. So you're going to be hearing from all of those stakeholders. They will continue to be a force in a Biden administration. They will be filing lawsuits. They will be active in congressional elections in 2022, and that's going to affect choices that an incoming Biden administration might make going forward in terms of the policy issues we've been talking about today. Next slide, please. So question is then, especially if you continue to have a divided Congress and you continue to have an inability of a divided Congress and an executive branch to work with one another, what can be accomplished through executive orders, through proclamations? And what you've seen both with President Obama and President Trump is that quite a lot of far-reaching changes can be accomplished through executive action. Inevitably, those actions are going to meet with court challenge by one set of stakeholders or another. And that is really what the risk is with using those sorts of tools is first that they are vulnerable to challenge, but probably the most important weakness of these approaches from my perspective is that they are not durable. And so certainly when I, as a DACA advocate, as director of USCIS, ever spoke about DACA, I said, DACA cannot be seen, if you care about the population that DACA helps, DACA cannot be seen as the end state. DACA is merely a holding action on the way to some more permanent status. Many prefer that to be a path to citizenship. You're going to have similar discussions about our asylum standards. Those are, these days very much a creature of regulation. What's in the law is really based on international treaties. So how we've interpreted here, certainly in recent years, has been defined by the executive branch. And you're also going to see a lot of discussion about temporary status, which Angelo defined very clearly before. You've had a number of attempts to terminate, including for El Salvador, which is the largest of the temporary protected status grants, a number of attempts to terminate those. I think it's reasonable to expect that a Biden administration will be attempting to roll back those changes. You see here a site to a blog that Angelo co-wrote, has some really interesting, provocative ideas in it. So I think I'm going to turn the rest of this slide over to Angelo to talk about some of what's been on his mind.
Before you do, Leon, I'm sorry to interrupt, Angelo. I wanted, for the benefit of our audience, to let them know what the CLE code is for those of you seeking CLE credit. It is SS, as in Seyfarth Shaw, SS 2534, SS 2534. Thank you.
Thank you, Diane and Leon. The blog in question is found on the Seyfarth Business Immigration Group, or BIG blog. And when you click on that link, you will see that this blog, which I co-authored with a noted professor of immigration law out of Cornell Law School, Stephen Yale Lair, is only one of numerous suggestions and sets of recommendations made to the Biden-Harris transition team and to the administration itself. There have been recommendations by the Migration Policy Institute, the Zollberg Institute on Migration and Mobility, Cato Institute, the National Immigration Forum, Immigration Hub and America's Voice, the American Immigration Lawyers Association, and the Alliance of Business Immigration Lawyers. I happen to know that there have also been proposals submitted from the immigration court system, and also from the State Department, from persons inside the organizations that are yearning for some restoration of due process in the immigration field. One of the things I think that's really key here is, as Leon said, and that is the enforceability and duration of these executive orders. They will be challenged in litigation because stakeholders are aplenty on both sides. And what we have found, as with the Wash Tech litigation, those were on the side against employment-based immigration. On many of the other lawsuits that Gabe was mentioning, they were on the side of pro-immigration stakeholder communities. And the interesting point to be made, and one of our questioners is asking this question, how likely would DACA survive the current Supreme Court if the states continue to pursue their lawsuit? Recall that DACA has been up to the court twice. The first time when there was only an 8-justice court, and they split evenly. That had the effect of restoring the state prohibitions on or opposition to DACA. But then again, the issue revisited, and with Justice Ruth Bader Ginsburg in the majority and Chief Justice Roberts, it was determined that DACA did not have sufficient due process protections in its elimination because it did not give adequate consideration to the reliance interests of the population in question and the larger American community, industry, academia, et cetera. Now, with a new Justice, Amy Coney Barrett, on the court, it's anyone's guess as to whether DACA would survive if it went up there again. Fortunately, there appears to be a bipartisan support level for DACA if it could come forward as freestanding litigation. Not clear that that will happen. So I think we can go to the next slide. What might it look like then if we were going to have broad, comprehensive immigration reform? If I had my druthers, and I don't, we would do it on a clean slate, and we would try to make some fundamental sorts of decisions about what kind of a country are we, what is family unity, and what does that mean to us? What is economic prosperity, and what is the role of immigration? Unfortunately, however, we have the 1952 Immigration and Nationality Act, and Diane's and Leon's excellent recitation of history demonstrated that what we have seen is add-ons and amendments and changes to a statute that many have described as second only to the Internal Revenue Code in complexity. And therefore, we may well have a continuation of that practice. Will it include a path to legal status or citizenship for the undocumented? I would posit to say that if it did not, it wouldn't be comprehensive immigration reform. Will it have a point system such as we see in Canada and Australia? And if it were a point system, who would value the points? And would it be the only way to immigrate, or would it be just supplemental to the other existing ways to come under the family-based and the employment-based systems? Too soon to tell. Should there be an Article I independent immigration court? Right now, many don't realize, but the immigration judges and the Executive Office for Immigration Review are creatures of administrative law headed up by the Attorney General. And our previous, current and previous attorneys general under President Trump, Mr. Sessions and Mr. Barr, have shown a willingness, in fact, an enthusiastic proclivity to restrict immigration by precedent decisions and instructions to the judges, the imposition of quotas on productivity that are anathema to the time of deliberation required for a due process determination of rights. Many organizations, the American Bar Association, the Federal Bar Association, AILA, have espoused an independent immigration court. I frankly would support the idea that it not just be for removal and deportation, but it cover every kind of adjudication under the administrative statutes governing it across the several federal departments. Time will tell whether that will happen. One thing that the Biden-Harris administration has suggested in its campaign materials is that they would want to give states, governors, regional economic development corporations, cities, the ability to earmark candidates for green cards based on the prospect of promoting economic development and jobs. We shall see. Leon, do you want to talk about the family versus business dichotomy and how that might play out?
I mean, I think that's going to be from a from an immigration reform standpoint. I mean, I think both issues are going to have to be addressed. I think you pointed to the path to citizenship. I think you also have a competing issue, which is, one of the centerpiece considerations in immigration policy is family unity. And so there have been a bunch of, pulls and tugs in terms of family-based immigration, as far as wanting to narrow pathways. You heard a lot of this talk about chain migration during this most recent administration. And it's created the dynamic that is inherent in this question, which is that it is a finite pool, finite visa pool as between family immigration and business immigration, that you want to have a system that sort of caps it overall and forces us to make choices between family and business immigration. Part of where I think this goes really astray, and I think this may ultimately emerge in the actual policy debate, is that the numbers we're talking about were determined in the mid-60s for the most part, and therefore they really represent an outdated sense of our demographics as a country, the demographics of the country, the sending countries, and so the debate. The most we can say about the debate is that it will continue, but it probably won't be resolved until there is some greater room being given to both types of immigration, because both, for close observers, are simply inadequate. And the talk here about immigration enforcement discretion, I do think, just to be very blunt about that, I think that will be both in law and in practice, that the pendulum will swing backwards from what we have, or swing back, not backwards, but back from what we've seen in recent years, and where you will see a higher level of forgiveness, more discretion will be given to immigration judges. I don't think that's going to be part of immigration reform necessarily, at least not in the short term, but I think it is going to be part of shifted practice within the executive branch. Next slide. Okay, and real quick about the Congressional Review Act. I think there's some one of the issues we've talked a lot about are these recent regulations that affect the prevailing wage structure, that affect the H-1B lottery structure, that have really narrowed the availability of H-1B visas. And so the question is, what can happen with these as a practical matter around the transition from a Trump administration to the Biden administration? One of the things that can happen is something called the Congressional Review Act, which gives Congress 60 legislative days. There's a few other procedural hurdles along the way, but 60 legislative days to pass a resolution that, in fact, would extinguish a regulation issued by the executive branch. It was used only once prior to the Trump administration. It was used, I believe, 14 times between the Obama by the Republican majority Congress post-Obama in early 2017. There's nothing in terms of what's been said publicly as to whether there will be an effort to reverse any of those regulations in the event of a Democratic majority Congress, or even of a differently composed majority Republican Congress going into the early part of next year. But that is certainly a possibility that the Congressional Review Act could be used and therefore be used to reverse those regulations that we've talked about, also with the public charge rule, certain asylum rules. What there will be for sure is litigation, and that probably could take us to a whole additional webinar. Other than that, all of these bills that we've talked about have been the subject of legal challenge. It is probable that those legal challenges will survive into a Biden administration. And one of the things that will need to be watched and will need to be a subject of some advocacy is the position that an incoming Biden administration will take with respect to those litigations. Will it resolve those litigations in a manner that either significantly ameliorates those rules or eliminates them altogether? Will they confess judgment, or will they continue basically to defend those regulations? Those are actually unknowns in terms of anything that the administration has said publicly, and therefore they are something that behoove this community that cares about employment-based immigration to consider what an advocacy strategy to really attempt to influence the position that will be taken by the incoming administration with respect to those cases.
One last point, Leon, that I think is worth noting is that it is very difficult to determine the extent to which the progressive wing of the Democratic Party will be supportive of greater restrictions and regulation of employment-based immigration. The H-1B category has often been the canary in the coal mine as to the direction of how there should be enforcement. We've heard the old phrase, politics make strange bedfellows. We may find that certain components within the Republican Party and certain components of the Democrats' left wing may make employment-based immigration far more strict than we have seen before. One thing about S-386 is that it will give a great deal of authority to the U.S. Department of Labor Wage and Hour Division, and time will tell what will happen with Immigration and Customs Enforcement and Homeland Security investigations and other enforcement arms. Diane, you want to go to questions? I think you're on mute.
I am unmuted. I think we have exactly 3 minutes. Kelly and Mike, I actually am not seeing the questions, so I will defer to someone who's seeing them to address the best of them.
I am seeing them, and one individual has asked about the ability to travel outside the United States and who are really eager to see family members. When will the consulates open up? That's a good segue into the recognition, as Gabe mentioned, that consular offices are largely opened under a system of health care protections that are dependent upon local conditions. So it first and foremost will be a reference to whether in the country where the visa application will be filed, there is likely to be a consular officer available and willing to grant a visa interview. And we have another question. The question deals with how can immigration attorneys advise on how to bulletproof their labor certification green card programs. That's really a tough one, because what we have seen recently with the U.S. versus Facebook complaint of last week is that employers can follow every rule with great devotion and compliance and still be accused of violating some other agency or department's rules. It's one of those reasons to suggest that we really do have to have a harmonized body of immigration law, and that's why I would espouse an all-purpose Article I immigration court, not just to deal with removal and deportation, but to deal with all of the administrative tribunal adjudications that are now the subject of federal court litigation.
I believe we're now at time, unfortunately. Please watch your email, because I'm sure we will be doing a number of additional webinars as we move into the new administration. Thank you so much for your attendance today, and we wish you all a good afternoon, good evening, or good morning, wherever you are. Thank you.
This concludes today's webinar. Thank you for attending.